there were conditions that would require it. For example, a large item, and there's a concern that there would be a massive amount of public commenters, therefore to effectuate social distancing and meet those requirements, your finding would be that members of at least 2 members could remotely attend in order to meet those criteria. Not that they would have to be absent every meeting. But if you do find that, but you could also find that social distancing does require that at least two members, because of the numbers in the room at every meeting, that it would be prudent to have 2 members remoting in for your meetings. But if you do make that finding that they must remote in because of social distancing requirements, it would not then be prudent to later during those 30 days have everybody appear together at once, if that makes sense. So, but those are options. They just should be related to the emergency that you have found to be existing and that must be addressed.
Well, I would move then that we proceed with some plans for social distancing, and whatever the commissioner's preference is, whether that should be shall or could. It seems to me we have more flexibility with could.
Yeah, I'm in agreement.
Yeah. Would you like us to make a motion as you've listed in here? Item number 3, I believe it is, B.
Right, the resolution isn't specific with respect to.
Yeah, you could make a motion to adopt the resolution, and well, let me pull the resolution up just to be sure that I have it correct. So yes, you'd make a motion to adopt the resolutions and the findings.
Okay, I would like to go ahead and do that. I move that the Planning Commission approve the consideration of the adoption of Assembly Bill 361 findings, authorizing teleconference meetings during a state of emergency.
Second?
First and a second. All in favor?
Aye.
Aye. So we have 21-1153, consideration of the approval of minutes from the October 14th, 2021 Planning Commission meeting.
Mr. Chair, I move that the Commission approve the minutes from the October 14, 2021 Planning Commission meeting.
I second.
Okay, all in favor?
Aye.
Aye.
Aye. 21-1154, consideration approval of minutes from the October 28th, 2021 Planning Commission meeting.
I'd like the record to reflect that I was present during the meeting via Zoom.
No, October 28th?
Yeah.
Okay.
With that revision, I move that we approve the minutes from the October 28, 2021 Planning Commission meeting.
I second.
Okay, we have a second. All in favor?
Aye.
Aye.
Aye. Okay, next is the 21-1156, consideration of proposed 2022 Planning Commission regular meeting calendar. Are we okay with the calendar as it's set for 2022?
It appears fine to me.
Okay. Do we need a motion to approve the calendar for 2022?
No, my understanding is the calendar as put on the agenda was for your information.
Okay. Okay, thank you. Okay, we'll take any citizens' input if we have any at this time before we take up our 905 item. Okay, seeing nobody in chambers, do we have anybody teleconferencing in?
There are currently no hands raised in the Zoom room. If you'd like to make a public comment, please raise your hand. You can do so by clicking on raise hand at the bottom of your screen. I don't see any hands being raised.
Okay, thank you. We'll take up our 9:05 a.m. item, public hearing to consider general plan conformity, GPC 21-01, CE 21-38, applicant owner Lori Doring, proposed project application for general plan conformity for the vacation of Dillard Avenue in Kelseyville, California. The Lake County Public Works Department is currently processing the application for the vacation of Dillard Avenue, location 3440, 3430, 3420, and 3400 Dillard Avenue, and 6420 Soda Bay Road, Kelseyville, California, 95451. Staff.
Mr. Chair?
Yes.
Hi, I just want to introduce myself. I am Mary Darby. I'm the new Community Development Director with the department, and I would like to introduce Laura Hall to provide the staff report for this particular case.
Nice to meet you.
Thank you.
Got it?
Right. Good morning, Planning Commissioners.
Good morning.
Can you hear me? First, I would like to bring to your attention the green sheet that was passed out this morning. There's 2 paragraphs on the green sheet addressing CEQA and the staff report. We had to make a change that's shown in the second paragraph. There's 3 words not subject to. Under CEQA exemptions 15060C2, the project is not subject to CEQA, so there is no exemption. And that's what that change is. Okay, this is a request for a general plan conformity in support of a road vacation for Diller Avenue in Kelseyville. The applicant is Lori Doring, and the project is GPC 2104. As shown in the location map, Diller Avenue is located between the properties outlined in purple, which includes APN 044-032, 0506, 0708, and 044-03102. All.
I'm sorry, we're going to have to interrupt for just a second. We need to share the screen.
Oops. It's on the right-hand side. Yep. Yep. There we go.
No, we keep opening it up. It's sitting there. And
Next
use
one.
your arrow keys.
All right.
Okay, could you start over because we lost the audience on it.
Start over
They
from
couldn't see
slide
what you
1.
were doing.
Slide 1.
It's still not shared, guys.
No, it says it is.
No, you're sharing the File Explorer window.
The which one?
You're sharing the File Explorer window. All we see is a list of 3 PowerPoints.
It doesn't want to hold that. This one, Jake? Can't see it.
It would be that one for the slideshow, yeah.
Yeah, that's it. There we go.
All right, that's it. Thank you.
Got it? Thank you. Okay.
Thank you.
Oh, and let's move this to the bottom so it's out of the way of your I'm going to replace this monitor.
Okay, as shown in the locational map, Dillard Avenue is located between the properties outlined in purple, which includes APN 044, 032, 05, 06, 07, and 09, and 044, 031, 02. All properties are owned by the applicant, and each is accessed from Dillard Avenue. This is the aerial map of the subject properties with associated assessor's parcel numbers. The Public Works Department is processing the application to vacate Diller Avenue, but before the department can recommend the vacation, the California Streets and Highways Code, Section 8320, requires the Planning Commission to first determine whether the road vacation conforms to the Lake County General Plan. The applicant is requesting the road vacation because historically Diller Avenue has not been maintained, which has led to unsafe conditions. Also, the road has never been improved past APN 044-03209, which results in public turnarounds on the applicant's parcels. The vacation would allow the applicant to improve and maintain the road, thereby eliminating unsafe conditions, and would end public access and turnarounds. This map shows alternative routes the public would take along White Oak Way, Live Oak Lane, and Canopy Lane following the vacation. Photos 1 and 2 show the intersection of Hopi Avenue and Diller Avenue. Photo 3 shows a 14-inch drop-off when accessing Diller Avenue from Hopi Avenue. Photo 4 shows the same with a note on the immediate change from asphalt to broken surface. Photo 5 is looking down Diller Avenue from Hopi Avenue and includes a not a through street sign. Photo 6 is a shot looking further down Diller Avenue toward Hopi Avenue, noting the road's unsafe conditions. Photos 7 and 8 show more of the road conditions, noting the part of Diller Avenue where the applicant's family has to navigate to walk in between the properties. Photo 9 and 10 show more of the same hazardous conditions. And photo 11 shows the end of Diller Avenue, approximately 50 feet from the lake where the turnaround frequently occurs on the applicant's property. In order to determine whether the vacation of Diller Avenue is in conformity with the Lake County General Plan, staff reviewed Chapter 6, Section 6.1, Goals T1, which states to provide and plan for a unified, coordinated, and cost-effective countywide road and highway system that ensures safety, maintains adequate levels of service, and efficient movement of people and goods. The vacation of Diller Avenue would allow the applicant to improve and maintain the road and thereby reduce the current hazardous driving conditions, and would improve the levels of service and efficient movement of people by rerouting traffic through White Oak Way, Live Oak Lane, and Canopy Lane as previously mentioned. The proposed activity only involves a report and determination concerning consistency of a potential road vacation with the county's general plan. Therefore, the proposed decision is not subject to CEQA pursuant to Section 15060C2. The activity will not result in a direct or reasonably foreseeable impact to the environment. Approvals for the vacation of the property would undergo further CEQA review through the Department of Public Works report. Staff recommends that the Planning Commission take the following action. The Planning Commission, after reviewing the agenda report and receiving evidence at the public meeting, finds that the location, purpose, and extent of the proposed vacation of the property located at 3440, 3430, 3420, and 3400 Diller Avenue and 6420 Soda Bay Road is in conformance with the County of Lake General Plan pursuant to California Government Code Section 65402. Staff recommends the following sample motion for the CEQA determination. I move that the Planning
Ms.
Commission...
Hall, you don't have to read us those motions.
Okay. And that concludes the presentation.
Thank you. We have any comments or questions from the commission?
Yeah, I do. I have visited the location, and it's very impressive what Ms. Doring has done to the whole neighborhood. She's employing people, and she's really contributing to the community. My only question is concerning fire access, and it looks like that's been addressed here. She says the Kelseyville Fire Department has stated they do not see any problem, so.
We'll actually have
Yeah, I think,
Yes, if you could please state your name for the record.
Lori Dory.
Are you you're the applicant?
Mr. Chair?
Okay.
Are
Yes.
you opening public comment at this time?
If she's the applicant, do we need to
Oh,
open
she's the
public
applicant,
comment?
okay, thank you.
We've installed a Knox box on the street for access if, as needed, because of, it faces Soda Bay Road as well. So that's been programmed by the Kelseyville Fire Department and signed off by them.
Could you please state your name for the record?
Lori Doring.
Thank you.
Mr. Chair?
Yes.
Ms. Doring's been before the commission before, I remember you.
Thank
And
you.
was impressed with the application you brought to us at that time. And this strikes me as a very straightforward vacation GPC finding.
Yeah, appreciate that.
Okay, any questions for Ms. Doring? Okay, if we have no questions, we'll open it up to public comment. Do we have anybody in the room wishing to make comment on this item? If not, can we look in the Zoom room, please, if there's any comments for this item?
Currently, there are no hands raised in the Zoom room.
Okay, I'll close public comment and bring it back to the commission for questions or action.
I don't have any questions. I'm prepared to make a motion if everybody's okay with it.
Okay, any questions? You're fine? No. Okay.
And it's going to be this one right here, right? I move that the Planning Commission find that the analysis of consistency of the road vacation with the Lake County General Plan is not subject to CEQA because it falls within Section 15060C2 of the State CEQA Guidelines, Division 6 of Chapter 3 of Title 14 of the California Code of Regulations.
I'll second.
Okay, all in favor?
Aye.
Aye. No, you don't. Is that the only motion needed?
One more.
one more.
Okay, thank you.
Thank you.
You want me to do it?
You can, either one of you can, however you'd like to do it.
I move that the Planning Commission find that the analysis of consistency of the road vacation with the Lake County General Plan is exempt from CEQA because it falls within section, I think that's the same one,
It
except
is the same one.
this one just
yeah.
has the correction.
This is confusing.
That's what I'm
Because
thinking.
this one
Looking for the
is
other.
exempt and this one says it's not subject to CEQA.
what she's done.
It's just the
is
bottom one,
she
right?
posted, the first one is the previous
Yeah.
text, and the second is the,
Oh, right.
so we're
Yeah.
good.
We're good. Thank you.
Thank you.
We read the revised motion.
My understanding is there was a CEQA motion and a general plan conformity motion. Were they combined in that green sheet?
No, I see what you're talking about.
No, there should be a motion on general plan conformity.
Yeah. I move that the Planning Commission find that the vacation of Dillard Avenue as proposed by Lori Doring is in conformity with the Lake County General Plan.
Second.
Okay, all in favor?
Aye.
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 Thank you. Sorry for the confusion.
So we'll take up the 910 item, 211158, public hearing to consider approving use permit UP 21-18. Applicant, Brelia and Race Consulting Engineers, owner Sunrise Shore Mutual Water Company, project description, general improvements to existing Sunrise Shore Mutual Water Company facility, location 6030 Sunrise Court and 6200 Sunrise Drive, Lower Lake, California.
Mr. Chair, Eric Porter, our staff with CDD, will be making that presentation.
Thank you.
Trish, can you pull the PowerPoint up? I can't see it. Thanks. Good morning, Commissioners. Eric Porter, Associate Planner, Lake County. We have before us an expansion and improvements to an existing water company. It's the Sunrise Shore Mutual Water Company located in Lower Lake. Properties are about a block apart. They total a total of 0.34 acres, and they currently contain some old tanks that are essentially need to be replaced, and infrastructure including piping and holding tanks that are also in need of replacement. So as far as what I'm going to be presenting, it'll be the project scope. Thank you. The permit request I've already indicated, it'll be a major use permit, which is required for any public or private utility. Scope of the project, site description, project analysis, recommendation, and did not include the conditions in the PowerPoint because it would have been too lengthy to put onto slides. Addresses are 6030 Sunrise Court and 6200 Sunrise Drive in Lower Lake. Properties are zoned rural residential, FF floodway fringe. Parcel numbers are 043-30204 and 043-31005. The applicant representing this project is Brelgy and Race Engineering Consultants Company. The two parcels are, like I said, about a block apart. They're on two different roads, but they're part of the same infrastructure. And I indicated the zoning is rural residential floodway fringe. Public utilities are allowed in the RR district, as they are in most districts, but they're subject to a major use permit. In this case, the water district was not eligible for a modification because of the age of the facility. It actually was built in the 1950s, I believe in 1958. And that's a lot of the reason why it needs to be replaced. It's just aging infrastructure. It's a picture of one of the two redwood tanks. The other one is kind of visible behind it, but they were installed, I believe, back in 1958 when the project was originally built. So this proposal includes a new 10 by 14 filtration building, a new aeration tank on a slab. They need to abandon two wells, one of which will be demolished, the other one will be decommissioned. They need to install new pipelines for the two 45,000-gallon tanks that they'll be installing. They need to remove the two 15,000-gallon redwood tanks, which is visible in that photo. I indicated the two 45,000-gallon plastic tanks. And they need to install a 4-foot tall retaining wall above, I believe, above the tanks. Description: both sites contain facilities related to the water company. Both sites have minimal improvements on each site. This view, by the way, is from the street looking towards one of the two sites. The two sites are, other than the water facilities, are generally unimproved and contain indigenous trees, shrubs, etc. Applicant did not indicate that any trees or shrubs would need to be removed. There are flat spots on the properties that can accommodate the improvements. I've already indicated both sites have aging infrastructure. So what we had to review it for is compliance with the Lake County General Plan, the Lower Lake Area Plan, Lake County Zoning Ordinance, and any applicable state regulations. There isn't a whole lot about public infrastructure to this scale, which is small, within the general plan. There are a few that are economic development related, although there's nothing in the material submitted indicating that this project would involve hiring additional employees. So the use of the water company itself is the value to the community. The project serves 34 different clients with public potable water. The Lower Lake Area Plan, again, there are really no relevant policies that relate to this project within the Lower Lake Area Plan. However, the project is not inconsistent with this plan. Applicable zoning ordinance requirements are Article 8, which indicates public and private utilities are permitted use in the rural residential zone. That's actually found in Article 27, Table B. And they do require a major use permit, which has been applied for by the applicant. The other applicable standards that I did not list are true for any major or minor use permit. In this case, it's a major use permit, and those are found in Article 51.4, which are the 6 requirements, findings that have to be met for a major use permit. State regulations. The State Water Board regulates utilities such as the Sunrise Shore Mutual Water Company, and specifically it's a state drinking water board. I don't think I have the name of that agency right, but it's overseen by a state water regulating agency. We did a Sql analysis for the project. I believe it's IS 21-35. And within that analysis, we found 4 potential categories that had some potential for impacts. Those included biological resources, cultural tribal resources, noise, primarily during construction, and mandatory findings of significance, which are a cumulative impact based on the first 3 categories. So the findings that we have to make are found in Article 51.4. And those 6 findings are similar to, well, they're identical actually to what we would apply to any major use permit review. And to summarize the findings, we have to make a finding that it won't be detrimental to the neighborhood, that its properties are adequately sized, shaped, and properly located for the facility, that streets, highways, pedestrian facilities are adequate, that there are adequate public and private services. Project conforms with the general plan, the applicable area plan, in this case it's the Lower Lake Area Plan, and with the applicable sections of the zoning ordinance, and that no violations exist of chapters 5, 17, 21, 23, or 26. So we were able to make those 6 findings. There are no conflicts within Article 51, subsection 4 that relate to this project. Before I get into the recommendation, I did want to state for the record that we did have a concern raised from a neighbor. Her name is Jamie Field, And her concern had to do with the placement of the fence. And I don't have a graphic of that fence, but I can tell you that the applicant relocated the fence in a manner that won't interfere with her access easement leading to the property. So I received an email from her indicating that she had no issue with the relocated fence. Fences do not require a permit if they're under a certain height. This particular fence is 6 feet tall, and so it can be built without permits. Getting back to the recommendations, we're recommending that the Planning Commission adopt initial study 21-19 and that the Planning Commission approve major use permit 21-18 with conditions. So with that, I'll entertain any questions or answer any questions that might come up.
Thank you, Eric. Do you have any questions from the commission?
I have a question. In your agency comments, CAL FIRE in paragraph 4 makes a statement that concerns me. If the AHJ, which I assume to mean authority having jurisdiction, chooses not to enforce minimum fire safe standards during the permit process that is required, the applicant to follow minimum state fire safe regulations required in the SRA. Is this, are they seeing an issue here, or is this just boilerplate? I see later in the letter they're referring to greenhouse setbacks, so I'm wondering if it's just a boilerplate.
It is boilerplate. Compliance with 4290 and 4291, Public Resource Code 4290 and 4291 can occur during the planning review process. However, it's also mandatorily applied during the building permit review process. It's delegated by the building official. Planning is not expertise in 4290 and 91, although most of the planners have some idea of what those regulations entail. So when they come in for a building permit, which is required for any water tank that exceeds or that is at or above 5,000 square feet, that requires a building permit. So they will have to come in, they will have to be reviewed for PRC 4290 and 4291 compliance. Properties that are less than an acre do not have to meet the CAL FIRE setback standards. They don't have to be 30 feet from a property line. They do have to meet the rural residential zone setback standards for the structures. And so that would apply to anything that requires a building permit. I think there may be an exception for the retainer. But again, I'm not a building code expert either, so I'm not quite positive what that setback would be from property line with the retaining wall.
Okay, thank you. I assume they're talking about access for vehicles, but I'm not sure. It sounds like it's being addressed, so thank you.
Any other comments, questions from the commission? Okay, thank you. We'll open this up to public comment. Anybody wishing to speak on this item, please come to the podium and state your name. Seeing nobody, we'll defer to the Zoom room if there's anybody wishing to make comment on this application.
There are currently no hands raised in the Zoom room. I do see, oh, I just had one pop up, but real quick, I do have one phone participant now. You can raise your hand by dialing *9 on the phone. The hand I have raised here is from John Losi, maybe? John, I've given you permission to speak. You should be able to unmute now.
Thank you very much. Yes, this is John Losi, project engineer with Brelgy and Race Consulting Engineers. First off, I'd like to tell the commission I'd like to thank your planning staff for their efforts on moving this work forward, and obviously especially those provided by Mr. Porter. Just as some point of clarification, we too had some concerns regarding the general conditions related that CAL FIRE put forward and that are related to fire issues. Just for points of clarification, At the tank site, these improvements consist of 2 bolted steel tanks and 1 concrete or block retaining wall that is non-combustible to replace 2 existing plastic tanks and 2 existing redwood tanks, both of which are combustible. So we're hoping and expecting that there won't be any overlapping conditions applied to that particular site as a result of this change. We have a somewhat similar condition or situation at the well site where there is an existing building that houses some filtration facilities and several small existing plastic tanks that provide some pre-treatment, post-treatment functions at that location. We are essentially replicating those facilities, but in slightly different locations as we need to maintain the integrity of the operation while the new facilities are being built, but with an extremely close proximity given that the existing site is very limited in size. This property abuts the public right-of-way. No driveways, et cetera, are being planned or necessary for this activity. And again, from our perspective, we don't see any application for the CAL FIRE regulations to this activity either. Staff has indicated that item 6 under general conditions is a standard condition, and he certainly wasn't going to, at our request, remove it. Perhaps the commission is not in the position to do so either, but we would like at least ask the commission to consider whether or not, under the circumstances, general condition 6 could be removed. If that's not possible, again, we'll just thank the commission for their consideration, and we will resolve any potential issues that may come out of that on down the line when we're implementing the project. Thank you very much.
Thank you. Do we have any other hands in the Zoom room?
No, I am not seeing any more hands in the Zoom room.
Okay, thank you.
Could we refer back to the change that was just requested? My document isn't uploading or downloading, and I'm having trouble finding it on the hard copy.
And I'd like to hear what our planner has to say about condition 6 as well.
Eric Porter again. I don't know that we have the authority to, well, I guess the Planning Commission would have the ability to modify conditions that are within the land use action. I'm going to read the condition. The permittee shall adhere to all regulations and or requirements of the Lake County Fire Protection District and or the California Department of Forestry and Fire Protection, parentheses CAL FIRE, including meeting and maintaining all of the requirements and or regulations as defined in 14 California Code of Regulations, parentheses CCCR, Division 1.5, Chapter 7, Subchapter 2, Article 2, Subsection 1273.00 through Section 1276 of the California Department of Forestry and Fire Protection, parentheses CAL FIRE, for emergency access and egress requirements. The applicant shall contact the Community Development Department for specifics. The way I'm reading that condition, which came, I believe, from CAL FIRE, strictly applies to accessing the 2 sites, and that the accesses into the sites need to be of such that they can get emergency response vehicles into the site. That's how I'm reading that condition. It doesn't say anything that I can read about interior improvements that might require whatever short driveways are involved to be brought up to CAL FIRE standards. So the way I'm interpreting that condition is it would have to do with the width of the gate, which has to be 2 feet wider than the entry, and it needs to be 22 feet wide in order to allow an emergency vehicle to access the interior. I personally don't see a need to remove the condition.
Nor do I.
It's a high fire area, and I'm seeing, if this map is accurate, a lot of homes down there. It seems to me that we should definitely include that condition.
I agree.
I'm in agreement. Okay, we're going to close public comment and bring it back to the commission.
I'm prepared to make a motion, Mr. Chair.
Okay.
I move that the Planning Commission find that the initial study, IS 21-19, applied for by Braille and Race Engineering Consultants on properties located at 6030 Sunrise Court and 6200 Sunrise Drive, Lower Lake, and further described as APNs 043-302-04 and 043-310-05, will not have a significant impact on the environment, and therefore a mitigated negative declaration shall be approved with the findings listed in the staff report dated November 18, 2021.
Second.
Okay, all in favor?
Aye.
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 I further move that the Planning Commission find that the Briley, excuse me on the pronunciation, and Race Engineering Consultants on property located at 6030 Sunrise Court and 6200 Sunrise Drive, Lower Lake, and further described as APNs 043-302-04 and 043-310-05, does meet the requirements of Section 51.4 of the Lake County Zoning Ordinance, and the major use permit be granted subject to the conditions and with the findings listed in the staff report dated November 18, 2021.
Second.
Okay, all in favor?
Aye.
Aye. I'd like to note the applicant or any interested person is reminded that the zoning ordinance provides for a 7-calendar-day appeal period. If there is a disagreement with the Planning Commission, an appeal to the Board of Supervisors may be filed. The appropriate forms and applicable fee must be submitted prior to 5 p.m. on or before the 7th calendar day following the Commission's final determination. Okay, we're going to take up item 3, 21-1159, 915, public hearing to consider approving an amendment, MMU 21-20, original use permit, UP 18-43, applicant owner, Sunny S. Ranch, Shannon Sanders, proposed project for 2,409 square feet nursery areas, greenhouse for immature cannabis plants in conjunction with previously approved file number UP 18-43, location 19424 Butts Canyon Road, Middletown, California.
Our staff, Eric Porter, will continue with the next 2 items.
Thank you.
Thank you, Mr. Chairman. At the request of the applicant, we want to request a continuance of this item. Their consultant was unable to attend. They're actually out of state, and they wanted to have representation here from the consultant. So they've requested a continuation until January 13th, I believe, if I have my date right. Time to be determined, but the date would be January 13th.
That is the second Thursday of the month.
Okay, that would be the right date. Thank you, John. Sunny, yes, yeah, but we've already covered it, so it's okay. No. We can do the next one, whatever the next item is.
Okay, we're going to...
We need to make a
We're in
motion.
agreement to
Yeah,
continue?
yeah, we need a motion.
I so move.
Second?
Okay, all in favor?
Aye.
Aye.
Aye. We're on to item 4, 21-1160, 920, public hearing to consider approving the amendment.
Your mic?
Sorry about that. Item 4, 21-1160, 9:20 a.m. Public hearing to consider approving amendment, MMU 21-22, original use permit, UP 18-35, applicant owner Green Bear Farms, Cali LLC, Weiss admin, proposed project amendment to original Canopy cultivation, area 16 additional greenhouses, 1A type 13 self-distribution license to allow legal transport of cannabis to and from the site, location 4680 Clark Drive, Kelseyville, California.
Thank you, Mr. Chairman. It just occurred to me that I got my 2 modifications reversed. The one that we had continued to January 13th was actually because of a water analysis. It was not because of non-attendance of of the consultant, it probably would be fine to continue that first item to the 13th, although they were anticipating having it continued to December rather than January. And my apologies, I got the two reversed. So I don't know if we can reopen the first item and move it up to December. If that's going to be problematic, then I think we need to leave it for January.
Okay, any thoughts from the commission?
I mean, the date is immaterial to me, unless there's a procedural reason for not being able to revisit what we just.
My concern would be anybody who was listening and heard the date certain and then tuned out after you had made a decision as a commission, that they are relying on that date certain and may not know that you will have changed it after the fact.
I think January would be fine for both.
Commissioners, this is Mary Darby. I think the January 13th date would be appropriate for this case.
Thank you.
Thank you.
The one before you presently is file number MMU 21-22. That would be Green Bear, Cali. They had requested a continuation until January when their consultant could be in attendance. And staff's fine with that. We're recommending that it be continued to January 13th as well.
Okay, I'm in agreement. We have a motion.
Second.
Okay, all in favor?
Aye.
Aye.
So we have item 5, 21-1161, 9:25 a.m. Public hearing to reconsider approving use permit UP 20-22. Applicant owner We Grow LLC, Zarina Achakova. Proposed project file 15 A Type 3B mixed light commercial cannabis cultivation licenses and 1A Type 13 self-distribution license. The applicant is proposing 32 90 by 120 feet greenhouses, 2 90 by 125 feet greenhouses for immature plant starts, 4 50 by 100 foot drying buildings, 1 200 square foot shed, 20 5,000 gallon water tanks, 1 6 foot tall galvanized woven wire fence covered with privacy mesh to screen the greenhouse from public view. Total proposed cultivation area is 387,600 square feet, roughly 9 acres. Total proposed canopy area is 330,000 square feet. The applicant is also proposing the removal of 130 blue oak trees, which will require a 3-to-1 tree replacement using similar species trees prior to the start of cultivation. Location 16750 Harrington Road, Middletown, California. Cultivation site 17610 Sandy Road, Middletown, and 19678 Stinson Road, Middletown, consisting of 309 acres.
Thank you, Mr. Chairman. Staff is requesting a continuation of this project to a date to be determined based on the fact that the draw that they are requesting would be considerable on a grid that currently can't support the amount of power that ultimately they would need. Staff's requested a more comprehensive power analysis, and to date we do not have the adequate analysis in hand. We had a discussion with the applicants yesterday. They wanted to have the item heard, and staff is not ready to move forward with any recommendation on it based on the power issue. So for that reason, we're requesting a continuance to a date to be determined. Likely it would be in January, but we're not positive yet because we don't have that power analysis in hand.
Okay, thank you. Can we get a motion? Are we in agreement for continuation? Okay.
I move to continue this item to a date to be announced or to be determined.
Second.
Okay, all in favor?
Aye.
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 Thank you, Commissioners.
Thanks, Eric.
Thank you. Okay, we have our item 6, 21-1168, 9:30 a.m. Public hearing to consider major use permit, UP 19-36. Applicant Brian D. Pensack and Garrett W. Burdick, Lake Vista Farms LLC. Owner Lake Vista Farms LLC. Proposed project, 5 cannabis cultivation areas with a total cultivation area of 25.8 acres, which includes 653,400 square feet of a Type 3 outdoor cultivation canopy area within a 600 square feet temporary hoop house, 1.5 acre nursery with an existing barn, shed structures, portable toilets, trash enclosures, vegetative waste storage areas, 2,500 gallon water storage tanks, Conex shipping containers, and 8x8 storage sheds for storage of pesticides, fertilizers, and hazardous materials, renovated 10x30 shipping container for security equipment and monitors, security camera 6-inch tall, cultivation area perimeter fencing and locking gates, address 2050 and 2122 Ogden Canyon Road, Clear Lake, California.
Mr. Chair, our CDD staff planner, Michael Taylor, will make this presentation.
Thank you.
Morning, Planning Commissioners
Good morning.
and public. This is a major use permit for UP 1936 and adoption of initial study. Why is it? I can't even see that. Slideshow. F5, okay. Awesome. So it's it's a major use permit. Let me just back up a minute. This is a continuation from the October 28th PC hearing, and there was a little bit of research that needed to be done by the applicant with the City of Clear Lake because the project borders the City of Clear Lake with regards to Article 27. It is located in an exclusion zone, and per Article 27, the city and the applicant need to come to an agreement on whether or not the city would permit the project within the sphere of influence. So the project name is Lake Vista Farms. The address for the project is 2050 Ogden Canyon Road, Clear Lake, and 2122 Ogden Canyon Road, Clear Lake. Parcel numbers 010-05301, 010-05302. The applicant is Brian D. Pinsek and Garrett W. Burdick, and the property owners are Lake Vista Farms, LLC. On the agenda is permit request, project setting, site scope, project analysis, recommendations, and conditions. The permit request is for major use permit, UP 1936. It's for cannabis outdoor, 15-acre canopy. The project is total 302 acres, and the zoning is rural lands, and the general plan designation is rural lands. The 302 acres is made up of 2 parcels. This is a location map of the project. It's here, and this is the City of Clear Lake. 2 state highways are in the vicinity, Highway 20 and Highway 53. As you can see, it borders the eastern edge of the City of Clear Lake. This is a larger image. So these are the 2 parcels that make up the 302 acres. Parcel 010-05301 is approximately 145 acres. Parcel 010-05302 is approximately 152 acres. This is the 2 maps you see here are actually from the City of Clear Lake General Plan 2040. So the SOI, so here is the City of Clear Lake. This is the area of sphere of influence. The project is located approximately here, and per Article 27, we need to come, the county, the applicant and the city and the county need to come into agreement as to whether it is an accepted project within the sphere of influence. The zoning for this particular area of the City of Clear Lake is C4, which is heavy service, commercial, and light industrial. The topography of the site for the 302 acres ranges from 0% to 30+. The lighter areas here, which most of the the cannabis project is proposed is 0 to 10%. This is hard to see, but there are streams out on the property, and they're Class 1, Class 2, and Class 3 streams. This is an image of, it's a little difficult to see there, image of the CDFW. Now they call out streams, oh gosh, it's hard to see. They call out streams down in the southern half, and there's streams up in the northern half of the property. This is per the biologist bioassessment report, and they call out a Class 2, Class 3 stream here, Class 1 stream up here, and various tertiary drainage areas. On the property, there are 4 culverts, which in the RFR were deemed by the engineer to be able to handle a live load capacity of 75,000 pounds for a truck, fire truck. There are 5 wells on the property, and they are located by these blue little dots here. There's 4 in 05301 and 1 in 010-05302. So the property was previously farmed for hops, approximately 13.6 acres. And we'll get to it in a bit what those look like, but also additional agricultural uses for walnuts. There's an existing 1,200 square foot house which is located approximately in this area here. Agricultural accessory structures also exist on the property, wells and irrigation from previous agricultural uses. This is just a continuation. What's going on here? What's going on with this PowerPoint here? Well, here are some site photos. It's difficult to see, but these are previous hops rows that are throughout the site. And this is generally an image of a road here going through the property. Project scope. The applicant is requesting approval of 15A Type 3 outdoor licenses. They are clustered throughout the site. So that would include 15-acre canopy area, over 18.75 acres of cultivation area, and they're also requesting temporary hoop houses. So this map shows the cultivation areas. There's basically 5, as I had mentioned, A, B, C, D, and E. They all vary in size, and also the cultivation areas vary, and the canopy areas vary in size. This is a chart showing the square footages and acreages of the various cultivation areas. So A, B, C, D, and E. For the site areas for all 5 of them, the total is 24.65 acres, and as you can see, they vary in area from 1.5 acres to approximately 8 acres. And the cultivation areas totaling for all 5 areas 18.75 acres, and for the canopy areas, as per Article 27, the max they can have is 15 acres. They are also proposing temporary hoop houses, and as you can see on the chart here, we've got the number of hoop houses and the square footages total of hoop houses that the applicant is proposing. Total hoop houses would be about 367 hoop houses over the 5 parcels.
And these would just be hoop houses, not electrified or anything
Not
else?
electrified, no plumbing, they're just hoop houses, yeah.
And of those various sites, what is anticipated in terms of grading besides what was already done inappropriately on Site A?
No grading is proposed for those hoop houses?
No,
This
on
site?
any of those 5 named sites, A, B, C, D, or E.
No grading.
I thought I read that there was some plan for Site E. Grading,
Minimal.
well, what does that mean if there's already been an issue with improper grading during early activation? Is it the applicant who's telling us it's minimal grading, or is that your
Well,
determination?
yes, so if the grading exceeds 50 cubic yards, then they would have to, per the condition.
Oh, I understand the condition, but
Yeah.
this just says minimal grading. And who is going to determine whether that was actual minimal grading or not when it comes to working on Site E?
Well, they would have to submit plans, and at the time, per the conditions of approval, they would have to submit plans showing the location of the hoop houses, any grading. If it exceeds 50 cubic yards, then,
Okay, the only place that grading was mentioned was Site E, but
yeah.
if that will all be determined later, let's hope it works out.
So site description. So these are, I've got 5 slides here in a series, and they basically describe each of the cultivation areas. So site A, as you can see, its canopy area is 4.07, and cultivation area is 5.9 acres. Now, each site will include a 2,500-gallon tank, 8x8 storage shed or conic container, trash enclosures, portable toilets, waste storage areas, and 6-foot-tall security fencing and locking gates. In this particular one, they're proposing a 10x30 shipping container, which will house the security, equipment and any other things related to monitoring the site for security purposes. Site V, this area here, is the canopy area is about approximately 5.25 acres, and cultivation areas is 6.56. This will also include the additional items as mentioned in A, plus the additional 6-foot security fence and lockable gates. Site C has canopy area of 1.16, cultivation area of 1.45, and all the additional items that were mentioned previously. They are proposing a on-site nursery for propagation and growing of cannabis for the cannabis operation. And that would be in a barn or shade structures. Site D has all the same items. Canopy is 2.98, cultivation area is 3.72 acres. And E includes all the same items with a 1.54 canopy area and cultivation area of 1.92. Water use. This particular slide shows where the wells are located on all 5 cultivation areas. There are 5 permitted groundwater wells, and the daily water demand as described here is approximately 2.1 gallons per minute per canopy acre, and then over the 15 acres, 31.5 gallons per minute. The well yield in gallons per minute is approximately 720 per minute, and which is basically 4.4% of all well yield, the daily water demand. And this would be over 120 days, so over 120 to 180 day cultivation, the annual demand would be 5.1 to 8.1 million gallons per year, or 16.6 to 24.9 acre feet per year. The well yield is 1,161 acre feet. So that basically is 1.4 to 2.1% annual demand in acre feet. So the hops demand was 43.6 acre feet per year, which, as you can see, is almost twice as the cultivation for cannabis of 24.9 acre feet per year. Drought management, conservation measures, monitoring and metering. So these are basic descriptions that the applicant has provided in terms of what they're proposing to conserve water. No water surface diversion, selection of plant varieties, use of drip irrigation, covering drip lines and mulch and similar to reduce evaporation. Water application rates modified from data from soil moisture meters and weather. Shutoff valves, daily visual inspections or irrigation system, immediate repair of leaking or malfunctioning since water use metering and budgeting, and water budget will be created every year, and water use efficiency from the previous year will be analyzed. So they had the applicant applied for early activation in 2020. They were approved for up to 640,000 square feet of cultivation area and 479,000 approximately square feet of canopy area. A notice of violation stop work order was issued in May of 2020 for hoop houses that were constructed on Site A. And
how many hoop houses were constructed?
I don't know exactly how many were.
I'll ask the applicant.
Yeah. And 56,640 square feet of grading on Site B. Corrective methods were agreed upon by county and the applicant to remove the hoops and stabilize grading and instead of stormwater management controls. Staff went on site visits in September 8th and 28th and confirmed the removal of the hoops, stormwater management controls in place, were in place, and required improvements in stormwater management controls. So when we went out there, it had been out there for a while, and there was some degradation in the wattles, and some of the fencing was down. So we asked them to repair all those. We then went back out on the 28th, and those were taken care of. And hence we issued a grade violation clearance for GR 2140. I just wanted to make a correction in the staff report. It mentioned lessee, but it's actually the applicant.
I had a question about that.
Yeah, so that is the applicant, which addressed the violations. On to project analysis, regulations review for compliance, Lake County General Plan, Lake Location Area Plan. That would be, there's a correction there, that's Shoreline Communities Area Plan. The Lake County General Plan, goal LU1, economic growth, economic and social growth, we address those. To prevent incompatible uses, coordination with surrounding jurisdictions, which the applicant has done with the City of Clear Lake and in coordination with the county. That is addressed in the conditions of approval, and it's also in the staff report of what that agreement is. Goal LU2, difference between areas, urban, rural, and resources, agricultural, residential, bundle. So it is a approved use in the RL district, rural lands district out in that area. So that is a consistent with the Lake County General Plan. Goal LU6, maintain healthy and diverse local economy. Yes, having an additional business out there would increase, employment and bring finances into the county. It would prevent incompatible uses because it is zoned RL, and so it is a consistent use out in that area with the approval of the minor use permit or major use permit. Provide current and long-range water needs. Yes, agricultural, residential, adequate water availability. That has been demonstrated with the hydrology report and the drought management plan, that it is adequate to supply water out in that area. So this is the general plan map. This area is all zoned RL. Shoreline communities area plan, protect, preserve quality and quantity of water. That has been demonstrated. Increase water supply with the hydrology report and the drought management plan. Increase water supplies and implement conservation techniques. They have demonstrated that with the drought management plan. Let me back up there. Reduce development on prime agricultural. The area is zoned, is not zoned, but is prime, it's grazing land, which is not considered prime farmland. So in a sense, that is not being built on prime farmland, it's in grazing land. Preserve lands. Preserve lands for agriculture, promote development of agricultural uses, preserve areas containing prime agricultural soils. Rural lands. Cultivation of commercial cannabis is permitted upon issuance of a major use permit. This is zoning ordinance for Article 7, rural lands. Article 27 permits uses of unique and special character acceptable upon issuance of a major use permit. We could consider cannabis use unique and of special character. Article 68 pertaining to hoop houses is the definition for hoop houses, and that can be further reviewed in the conditions of approval. Article 7, 27, and 60 does not outline the quantity in square feet for hoop houses. This is zoning map, and this is the project, and this area is zoned RL, which is considered a use for cannabis. Development standards, Article 27, minimum lot size, A type 3 is 20 acres for Article 27. The Article 27 states that for every 20 acres, you can have 1 acre of outdoor cannabis, and so the 302 acres would equate to 15 acres of canopy. They have met all the setbacks from property lines and off-site residents. They're proposing a 6-foot height fence, and the maximum canopy area, as I had mentioned, is 1 acre per 20 acres for A type 3 outdoor.
Can I interrupt for just a minute?
Yes.
I'm a little confused. So are hoop houses considered outdoor?
Yes, I
Thank
believe
you.
they are. California Environmental Initial Study, IS 1956, was performed, mitigated negation, circulated June 8th, 2021 to July 12th, 2021. Local tribes were notified on October 18th, 2019, and through the Sql noticing. Potential environmental impacts related to aesthetics, air quality, biological, culture, and tribal resources and noise can be mitigated to less than significant levels. Several tribes responded, but no consultation was requested, or a project was not within the culturally affiliated tribal territories. Recommendation for California Environmental Impact major use permit submitted by Brian D. Pinsek and Garrett W. Burdick is recommended to be categorized as a mitigated declaration, as staff has determined that all impacts can be mitigated and reduced to less than significant. Mitigations are outlined in the attached proposed conditions of approval and initial study. These are the findings for Article 51 and Article 27. Article 51 is for major use permits. Article 27 is for cannabis. No impacts to surrounding neighbors. Project shape is adequately sized and shaped. Streets, highways can accommodate the project. Adequate public-private services to project. Conformance, no known violations of county code. Article 27 complies with all development standards. Applicant qualified to make application, meets all qualifications of permit. Staff has determined that the proposed project complies with the major use permit findings. Staff recommends the Planning Commission take the following actions. Adopt mitigated negative declaration, IS 1956 for major use permit 1936 with the following findings, and these are the mitigation measures that are outlined in the staff report and the conditions of approval, and they'll be further reviewed there. Approval of major use permit UP 1936, staff report fully outlines conditions of approval, aesthetics, air quality, geology, soils, water quality, hydrology, cultural resources, wildfire, and the permit is valid until date November 18th, 2031.
Mr. Taylor?
Yes.
What about the condition that was worked out with the City of Clear Lake? You haven't addressed that.
That is, yes, that is, and I will go ahead and read that to you here. So it is a part of the conditions of approval. And so I believe the county and the city came to an agreement on what that condition might be, and it's addressed here in the conditions of approval, and I can go ahead and read that if you like.
Yeah, you just hadn't, you didn't list it on the presentation.
Yes. And so let me go ahead and read that for you for the record. Prior to construction operation, the applicant shall reach an agreement with the City of Clear Lake as to the appropriate mitigation to address the impacts of this project on the City of Clear Lake portion of Aguilin Canyon Road. The amount of any mitigation fees or other mitigation measures shall be determined by the City of Clear Lake. If calls for service for the Clear Lake Police Department result in more than 5 call-outs by the city police to the project site in 1 year, the applicant shall supplement its security measures by the addition of hired security personnel on site 24 hours per day. In the alternative to security personnel, the city may instead accept reasonable mitigation fee to address the additional obligations on city police or other security measures as acceptable to the city. The applicant understands and agrees that the violation of any federal, state, or local law or regulation, contractual obligation relied upon in the issuance of the permit may result in the revocation of the permit.
And has the applicant provided a letter of support from the city? That's a reference on page 13 of the staff report.
No, they have not.
Why not?
I'd like to defer to council for...
Okay. It states clearly here that a letter of support from the city needs to be provided by the applicant.
That's what we've been waiting for.
Yeah.
That's why we continued.
Yes.
And is that no longer, and that is still not yet available?
So staff from CDD, I spoke with the director or the city manager for the City of Clear Lake, and he was supposed to be at this meeting today to speak upon that.
Mr. Chair, if I may.
Can you please state your name? Are you the applicant?
Yes, my name is Richard Knoll, and I am a land planning consultant located in Lakeport. And we have a presentation that we're going to make, but I do want to respond to the question regarding the setback letter. We have received a setback letter of approval from the City of Clear Lake. The City of Clear Lake City Manager, Mr. Alan Flora, is here today. We went to the City Council in Clear Lake some months ago and addressed this issue with the City Council, and a letter of approval was issued by the city, which was also provided to the county.
We haven't seen that
We
letter.
haven't seen it.
We have a copy here today. I've got a digital copy that we can provide, and Mr. Flora can speak to the issue as well.
Thank you.
Yes, please state your name.
Chair Brown, Commissioners, good to see you this morning. Alan Flora, City Manager, City of Clear Lake. So, yeah, the letter of support was provided to the county in February of last year. I have a version electronically. I'd be happy to share with you.
This isn't a question for you, but if the letter was provided in February, why did we have to continue this hearing from the previous calendar date? I thought we were waiting in anticipation of that letter, and that's why we decided to continue.
Commissioners, if I may, the letter that was provided previously was conditioned on the count of your commission adopting conditions into the permit that your commission did not have the authority to adopt. So it was just on the face of it, if the county did not adopt those conditions to the permit, then that letter was no longer a letter of support from the city of Clear Lake.
I remember now, thank you.
Thank you.
I'm happy to speak to that or address any questions in more detail if you would like.
No, and perhaps I'm misunderstanding something, but I'm confused that there was a reference to a letter that must be supplied by the applicant, and if a letter's existed since February, I'm just surprised it's never been made available to the commission.
Yeah, there was a little, after the continuance of the last meeting, there was some communication between the city and the county related to the conditions. I was able to talk directly with Ms. Darby and Ms. Grant about the conditions, and we were able to come up with some language that county staff were okay with, a little different than what was in the letter of support, but we felt like addressed the concerns that the city council had in issuing the letter related to use of city roads and impact on our police department. And so from the city's perspective, we've been able to address all the issues. We have an agreement with the applicant on road mitigation payment, and so the letter of support that was issued back in February stands based on the conditions that are before the commission.
Thank you.
I have a question. It's kind of a legal question. Do you have the authority to represent the city of Clear Lake in this matter?
Yes, I do.
Okay, thank you.
Any other questions for Mr. Flora or the applicant? No? Okay, we're going to open this up to public comment. Anybody wishing to speak on this item, please come up and state your name, or if you're in the Zoom room, raise your hand.
Mr. Chair, just a point of order. We have a presentation that we'd like to make as the applicant. Are we okay with that?
Yeah, that'll be fine. I will close public comment, and then we'll entertain your presentation and then reopen.
Thank you, appreciate that. May we come up and
Yeah, you
sit
can come
down?
up to
We have
yes.
a PowerPoint presentation. And
Real quick, while there's a silence, I know you mentioned that you wanted to close public comment before taking up this presentation. We do have 2 hands raised in the Zoom room, if you want to take those.
We'll wait till the presentation.
Okay.
Thank you.
Going to sit here, or they have to sit here, or are they going to be sitting over there? Okay.
the staff report.
I think this is the old PowerPoint from staff. And then you can just go to slideshow at the top and start slideshow. It's also the 5th icon on the top left.
Here?
Slideshow.
There?
That's it. Wonderful. Thank you.
Okay. So might help if we had our, thank you. Thank you all for the technical help here. Again, I'm going to introduce myself. I'm Richard Knoll, consultant out of Lakeport. I'm here with Mike Mitzel, who is also representing the applicant. And I do want to apologize. The applicant, Lake Vista Farms LLC, Brian Pensack and his partners are actually on their way here, and they have pulled over, I think in Cloverdale, and because they were anticipating that this matter would be much later in the day, so they are not going to be here in person, but had hoped to be. Also have Angie Dodd, PhD, Vice President, North Point Consulting Group out of Arcata. She has participated in many of the technical documents associated with this project. She is also attending by Zoom, and so if there are technical questions, we can hopefully ask Angie for input. So I want to thank staff and the Planning Commission for your staff report and recommendation, and for the Planning Commission's consideration of the project. I've got a PowerPoint here that I'm going to go through fairly quickly because much of the information has also already been provided. But we've got 2 parcels located northeast of the city of Clear Lake, adjacent and contiguous to the city of Clear Lake. 302.4 acres. Under the county zoning ordinance, the project qualifies for 15 acres of canopy. Let's see. Click to go forward.
These areas.
What did you do? Just a space bar? Okay. So the site assessment that was originally done for the project identified 5 different areas that would be appropriate for cannabis cultivation based on a number of factors: setbacks from watercourses, use of previously cleared agricultural fields. As mentioned, it's been a working farm for many, many years, hops and walnuts. So the sites that are being selected for cannabis are essentially previously farmed sites, except for, as I understand it, the Site E, but it had actually been cleared but never really farmed. This is just a chart showing the canopy areas, the cultivation areas, and other proposed site improvements. This is a cover sheet for the project. You can see the sites A, B, C, D, and E. Information concerning those sites, including stormwater best management practice, a legend concerning those. And then there are a multitude of additional site plans that I actually have here with me if there's a need to sort of focus in on anything that you may have a question about. Access to the site is a gravel driveway from Ogulin Canyon Road. There is a system of well-maintained driveways throughout the project site. And some discussion here about the previous agricultural use. As has been mentioned, and I think it's important to stress this, early activation of use was issued by the county in 2020. The site was leased to a grower, and there was a problem. And that problem resulted in the county issuing a citation, notice of violation, stop work order. The early activation was what's the term? Terminated. So it does not apply any longer to the site. And the applicant...
Just ask you a question. Why was there a lessee in the mix as opposed to simply the applicants?
I think that was a business decision to go that route.
And did the lessee go through the proper background checks with the sheriff's office and all of that?
I believe so, but I don't have definitive information about that, Mr. Hess. But I do want to stress the fact that
Did the applicants advise the lessee about the rules with regard to early activation? I mean, why would the lessee have begun in unpermitted grading and hoop house construction?
Well, as far as I know, the answer is yes. Mike, I don't know if you want to respond to that.
Yeah, I was with the applicant when the early activation was issued. The leasee, he was with us in community development when Scott signed the early activation. He was definitely aware of the rules of early activation, and they just chose to go the other route with it. Once we were notified that they did do the illegal grading and built the hoop houses, which was very soon after it happened, code enforcement came, I believe, within like 3 to 4 days once they started building the greenhouses. And as soon as the property owner was notified, they took every action they could to correct it. We immediately had the grading plans done and had everything removed within 7 days. And the property owner definitely went and did everything they possibly could. They terminated the lease with the leasee, so the person that did the illegal grading is no longer part of the project. And I truly believe that the property owner has done everything they can do to get rid of the leasee and to bring the property back into compliance as soon as possible. And it was done within a week, and the county basically sat on this project for about a year. So they definitely paid a heavy price for what happened, and I witnessed it with my own eyes that it was not the property owner that did the illegal grading.
Well, I understand how you're parsing it in terms of the property owner had nothing to do with it, but the property owner did enter into an agreement with the lessee.
Yeah. And if I can just have some clarity from our council, maybe it is ultimately the property owner's responsibility, am I right?
Well, let me try to answer that question.
The question was for council?
I didn't realize that. I'm sorry.
So my understanding, well, Ultimately, a particular grow is the responsibility of the permit holder.
So it's not the property owner necessarily?
Well, if the property owner were the permit holder, or one of the permit holders, who went through the process of applying and background checks and so on, then certainly they would have the right to grow under the permit that they are, to which they are attached, or that they are responsible. I can't speak to whether or not this lessee had their own permit for that particular property to grow, or, but my understanding is that once an individual applies for a cannabis permit, that permit can then not be leased out to others who have not also gone through the permit process.
So the state licenses would have been in the leasee's name, and all of there would be some like some of it would fall onto the leasee, because the water board permit would be in their name, so any like water board violations would fall on them. It's kind of a split bag, but with the county, it goes to the landowner. But the state licenses would have been all in the leasee's name, so they would have held some responsibility.
I can't speak to how the business in this case was structured. What I can do is tell you that any individual involved with the county permit, my understanding is that they would have had to been a part of the permit processing. They too would have had to gone through background checks, as do any of the employees, and they too would have been participatory in that, and not necessarily a silent individual who's acting independent of that. I don't know the structure here. It wasn't included in staff's material. If you have questions as a commission and you would like this to be clarified, you can certainly ask. If, as you seem to envision, that it was the applicant, a separate applicant who applied with the county to grow under a county permit, who then leased to a separate individual who was unrelated to that applicant, then my understanding is that our zoning ordinance does not allow for that.
I'm ready to move forward. I'm kind of curious what it's part of my broader education. We can address it another time, but I'm not sure that it's entirely relevant at this point, so thank you.
Let me just say this. A violation did occur. The stop work was issued. The EA was terminated. A mistake was made, clearly. I don't think the applicant, has avoided that relief in any way. I think the key thing at this stage is that corrective measures have been taken and have been verified and authorized, approved, if you will, by the county. So in many ways, we're back to what might be considered sort of a clean slate here. So anyway.
If I could just observe one final thing, and I think you're right about kind of hitting the reset button, et cetera, but as the only commissioner who's voted on every single cannabis application since the first one, it's become clear to me that the real problems with inappropriate activity on sites comes with early activation. There seems to be some kind of oversight gap or a lack of attention paid, and I can't think of an application where the problem was after early activation. And I would just like to observe that I think we need to tighten up that part of the process. Thank you.
Mr. Hess and planning commissioners, I've had this conversation with many other clients and folks involved in this process, and let me just say personally, I couldn't agree with you more that that early activation has not by itself created the problem, but it's that implementation of the project where there seems to be this gap between understanding what the rules are and what the conditions are and what happens out in the field. And ultimately, and I don't want to get on a soapbox here, but we actually had this conversation yesterday. This process is really about conforming to the county requirements and doing so to the letter of the law. And that's what's critical here going forward, really for the industry, but for the county and neighbors and everyone else. Anyway, moving on. As indicated, this project is contiguous to the city of Clear Lake. A letter of support was issued to the applicant in February 2020. This shows the location of the project relative to Clear Lake's city limits. Numerous documents have been submitted with respect to this project. You don't always see everything, but there's an awful lot that is in the record, and I just wanted to sort of illustrate that by showing you this document, which was submitted to the county at a time when the county was accepting paper documentation and applications. So there's been a lot of background and documentation presented, and it is available in the event that there are any questions. The county did prepare a Sql initial study. There's been discussion about the potentially significant environmental impacts. Mitigation measures have been set forth by the county and have been agreed to by the applicant. The site is located, even though it's adjacent to the city of Clear Lake in a rural area, and the proposed cultivation activities are agricultural in nature. It is not located or visible from a scenic highway. Biological assessment was prepared. Setbacks comply with California Department of Fish and Wildlife and county requirements. Erosion control measures will be, and in the case of the illegal grading, which has now been permitted by the county, substantial storm drainage mitigation in the form of wattles and silt fences and seeding with a ground cover has occurred and has been inspected and approved by the county. Cultural resources assessment was performed, and no significant archaeological or cultural resources were found, and in order to ensure that any undiscovered resources are not impacted, the standard county conditions, including on-site observation, will be implemented. As indicated, there are 5 existing permitted groundwater wells. Here's information about daily irrigation water demand. And basically the conclusion is that there is sufficient well water available on the site to provide irrigation for the proposed plants. Lake County Fire Protection District is within approximately 2.5 miles. There's an open source of water for helicopter use in the event of a wildland fire. We've actually prepared an emergency procedures and fire protection plan, and will also be required to comply with CAL FIRE standards. As indicated, there's been a history of farming activity. In terms of access to the site, as mentioned, it comes off of Ogillan Canyon Road. We actually prepared a traffic report addressing this project and several others in the area. The county didn't ask for that, was not actually provided to them, but it was prepared. and there's good access to the site. There's an existing security gate that exists, and it's set back from Mogollon Canyon Road. And in general, the on-site access is very good. There's a developed system of roadways that serve the prior agricultural activity. So things are in good shape in that regard. In our opinion, the project is in conformance with the county zoning ordinance and the county general plan. We feel that we presented a comprehensive major use permit application. We followed up with the hydrology report that the county's been requesting of all projects, as well as a drought management plan. And we are thankful for the staff recommendations. We agree with what has been proposed, and we thank the Planning Commission for your consideration of the project, and we're available to answer any questions that you might have. As are, I believe, the applicant and Angie Dodd, who is also online as well.
Thank you. Do we have any questions from the commission?
Yes. In the materials that were presented to me, this proposed removal of some walnut trees, but no oak trees, is that correct?
There's
Maybe,
there's a walnut orchard on the property that will not be removed.
okay. I'm familiar with the property as I knew the hop growers, and I remember that it's very rough terrain, and I'm concerned about erosion. This feeds into, it's the watershed for Burns Creek, right? And that flows directly into Clear Lake. Am I right? Okay. So you mentioned organic materials. I read in here some, I mean, there was a lot of reading material. I can't say exactly where it was, but you were talking about bringing in organic materials.
Yeah, just like organic amendments to amend the soil.
Okay, do you mean organic matter, or do you mean OMRI-approved substances?
They'll mostly be OMRI approved, but there's no like hard, fast rule that they have to be fully organic substances, but in general, they will mostly be all organic.
Okay, I'm just wondering if we're going to be seeing a lot of soil transportation, that kind of thing.
There will be very little on that site because it will be farmed in the natural.
Okay, so you're not going to be hauling in topsoil or anything like that?
No,
okay.
That's pretty good dirt there.
Okay, thank you. The California Historical Resources Information System, Chris, identified one building of historical significance in the agency comments. Can you tell me about that building and what your plans are for it?
I believe, and I am not entirely sure, but I believe it's the existing single-family house. Yeah.
Oh, really?
There is a metal barn in, I think, Site C, and but the house is probably vintage 1940s,
something
maybe
like that, yeah.
50s.
If it's over 45 years old, that's probably
yeah, then
a
it's,
structure.
yeah, okay.
Yeah, the metal building is like brand new, and the house is the only thing that would have any age to it.
Yeah, okay, I'm familiar with that. It's not of concern. Okay, so I looked at the drought management plan and the hydrology report, which were, I think, transposed in this online, but the hydrology report is based on that 6 gallons per day and 500 plants per acre. Is that actually what we're looking at? 500 plants per acre? Because that's like, I mean, that's like a spacing of a pear orchard.
Yeah, there's definitely a bunch of different ways to grow cannabis, and to tell you the truth, the amount of plants doesn't really isn't the determining factor of how much water you use. It's a lot more to do with the amount of area that you're growing those plants over.
Right.
So you can grow a lot of really small plants or a couple really big plants. And I've been growing weed for 30 years, and there's really not a lot of water use fluctuation. It more depends on the square feet that you're growing. So in that calculation, they do it by plant, but really it comes down to like the acres that you're growing, and it's pretty spot on, the number, regardless of if it's more plants that are smaller or the 500 plants that are bigger.
Yeah, I think it's more of an issue of how we're evaluating it as a county, but it looks like you have plenty of water, so I'm not worried about it.
There's a lot of water there, yeah.
Yeah.
The hops farm was ran on 3 of those 5 wells, and they used more water than Cannabis, and then we've put in more wells since the hops farm was there, so it definitely has the water to operate.
Yeah, I could see that. Thank you. That's all of my questions.
We have any questions from the commission? Okay, I have just 2 questions. One is more of a kind of the process, administrative process. Regarding the CRIS reports, I'm wondering if the firm, the cultural resource firm that is identified as filed the current report that's mentioned in the package with the CRIS Center.
I don't know the definitive answer to that. I believe it was, but I don't know for sure.
Okay.
To be honest with you, I'm not sure exactly what that process entails. Are you familiar with?
I do have some familiarity with it, and one of the reasons why I bring it up is what I've been noticing is when we're getting information back from CRIS, there's a lot of times they'll say that there's no report have been filed for this property. And what I'm finding out, reviewing some of the previous projects, and historically, a lot of the firms are not filing those reports in CRIS. So when a new project comes up and CRIS is asked to inventory, is there any locations, any reports, a lot of times they're going to say they don't have any information. And so my concern is if the report's not being filed by the cultural resource firms that are being contracted to do the work, then it's a concern of mine moving forward in terms of projects, the possibility of identifying historic or prehistoric resources on the site. So I was just wanted to know if you were aware of if that was filed. Is it planning to be filed if it's not? And then the other question in relationship to the initial study, one of the concerns I have with this area is wildlife corridors, and I'm not sure how far, if the Tule elk come onto this property, but that's a concern. I have seen them on 53 a number of times within the last few years, so I'm not sure if they're accessing this specific property or not, but in terms of moving forward, those are kind of questions I'm going to be asking in terms of those corridors. I see it says here in the initial study, no specific wildlife corridors exit within or near the study area, so I just wanted to ask if you guys are aware of any of those Tule elk coming through the properties.
We've never seen the Tule elk on the property, but the way that the project is designed with the 5 separate little grow sites with all of the canyons in between are still open, there isn't like a big strip of the property that's cut off. I feel like the way it's designed definitely helps for wildlife to be able to come on and off the property.
So you're not fencing the entire project?
No,
Okay,
no.
great.
There is some old fencing around the parcel, but it's not maintained, and our fencing will be right around the grow sites that were mapped.
Okay, thank you. That's the only questions I have. I don't know if you have a
Mr. Chair,
response. Yes.
just to respond, I think it's an excellent question about the wildlife corridors. And I mean, I understand the importance of maintaining corridors, historic corridors, you know, because animals, particularly elk and deer, will historically follow those paths that they've used for, you know, thousands of years. And so it is important. I was looking last night at kind of a regional view, and there is apparently a dirt road access from this site through various private properties over to Highway 20, where you often see the elk herds. So I don't know if they're using that road. I've never seen any evidence of any elk on this site, but I'm not out there all the time either. But, you know, it makes sense to try and preserve those corridors if there are any existing, in my opinion.
There is no roads behind it, but there's fire breaks on the ridge. So if you look on like Google Earth, they look kind of like roads, but they're just bulldozed the ridge lines all the way, like pretty much all back through those hills. So all the tops of the hills are ridged off.
Thank you. So if there's no questions from the commission, we'll open public comment. Anybody wishing to speak on this item? Nobody in the chambers in the Zoom room, please raise your hand. Oh, we do have one here.
Alan Flores, City Manager, Clear Lake. Just one minor clarification that I don't think impacts anything, but I just wanted to correct the record. So it was mentioned in the staff report that this property was in the sphere of influence that was listed in the city's general plan. That sphere of influence was never adopted by LAFCO, so the city's sphere of influence is coterminous with the city boundary. However, with the county ordinance related to the letter support, because it's adjacent to the city boundary and within 1,000 feet of it, it still requires a letter support. So I just wanted to provide that quick clarification.
Thank you. Do we have any hands in the Zoom room?
Yes, we do have some hands raised in the Zoom room. We'll start with the first hand we had raised from Jennifer Smith. Jennifer, I give you permission to speak. All right, looks like you are yes. We can hear you. Will you please state your first name?
Go ahead. Sure, Jennifer Smith. I'm actually calling in on I raised my hand to speak during the previous agenda items today. There was no public comment, so I can go through with that now that I'd like something to be addressed, or I can wait a minute and we can talk about this project.
The project that the item we're currently on is the topic. So if your public comment.
Will you be opening up public comment for the ones prior to this?
No.
Okay.
Do you have a comment in relationship to this project?
Not at this moment. I'm just really perplexed. Eric Porter messed up dates on the projects, and those dates are very important to those projects that the one is heard in December, not January, because of state deadlines. And I think you need to reconsider fixing the request of those projects.
Do we have anybody else with a hand in the Zoom room?
Yes, there are other hands raised in the Zoom room. The next hand I have up is from Bobby Dutcher. Bobby, I have given you permission to speak. All right, looks like you're muted. Will you please confirm your first and last name?
Bobby Dutcher, Lakeport. I was the listing and selling agent on the property when it sold a few years ago. So I have worked on that property for a couple of years. For Tule elk, to the north of it, elk use those properties quite a bit, but for some reason they don't seem to want to cross Black Eye Canyon. So I've never seen any evidence of elk on the subject property here. For some reason they just don't want to cross that canyon. I'm not sure why, but there's quite a few elk north of it, but they don't seem to like to come onto this property. And when the distance between all the different grow sites, there's plenty of wildlife corridors in there. There's some pretty major trail systems to the east of or the south side of the property, and the cultivation sites don't affect those at all. So the hops that were grown on there, hops are like a type of cannabis plant. The little buds that come off of them, they kind of look like the buds that grow on the cannabis that has the THC content in them. When you grind them up in your hands, it smells just like cannabis too. So since there was that type of plant was been growing on there for years, it seems like a perfect site for a cannabis operation. But some of my clients that have properties around these have already been approved by the county for cannabis use. On Augulin Canyon, the city just approved, the City Planning Commission approved another cannabis project for these owners, like say a few weeks ago. So this is an area where cannabis has been accepted. So it seems like a really good place to have, have more projects. The only downside really seems to be the sins of the former tenant. And I kind of feel bad about that. When they were really activated the first day, I saw them start to assemble a steel framed greenhouse. And I thought, I don't think you could do that in early activation. And looking back, I really wish I would have stopped them. So the owners weren't around during that week when the tenants were created these violations. As soon as it was brought to their attention, they did take actions right away. But yeah, I really wish that I had stopped in and had a discussion with the tenants on the first day when I saw the first greenhouse go up. So I really, that's the only downside. It's no fault of the owners. So yeah, I really hope that you will approve the project. Thank you.
Thank you. Do we have any other hands?
Yes, we have more hands in the Zoom room. I have 3 more total right now. The next hand I have up is from Dave Hughes. Dave, I've given you permission to unmute.
Can you hear me?
Yes, we can hear you. Please confirm your first and last name.
Okay, yeah, I'm Dave Hughes. I'd like to speak after some of the other people, if that's possible.
Yeah, I could pull you up at the end.
Thank you.
Do you prefer? Okay, all right. I will move on to the next hand I have up from Vicky Crystal. Vicky, I've given you permission to speak.
Yes, thank you. I'm Vicky Crystal, and I am a resident in Burns Valley, across the street from the Augulin Canyon site. I do have my concerns. Over the years, 40 years, with the vineyards that have moved in, I've slowly been losing my well water. With the drought, it has been even worse. Every year now, we are losing water in our well and often draw dirt into our drinking water early in the summer months. We have put in a close to 11,000 gallon cistern that helps us with our to water our small personal vegetable garden. And this year it was not even sufficient because of the drought, and we had to purchase water. I'm curious about the long-term effects of more water usage. And I am extremely concerned about the pesticides that was mentioned in the write-up. I mean, we talked about the organic materials, or not, that the materials that we're going to bring in, but there is pesticides that will be used up there. And as well as, the odor. I've never been opposed to it, but that's a lot of odor. And then after listening to this entire conversation, I'm even more concerned. The way it was presented, there are not enough definitive answers to a lot of these questions. And to be determined later is just not acceptable to me. So, thank you.
Thank you. Next hand, please.
All right, the next hand we have up is from Hyperlight.
Yeah, good morning. This is John Wilcox, neighbor. I'm calling with 6 concerns. Number 1, bottom line, the applicant is responsible for the actions of their lease, so I feel this is a reflection of the applicant. Number 2, only the grading violation is being discussed. The location had over 40,000 plants in violation of state law and metric tracking, as they did not even have their state license prior to growing into the early activation. Number 3, considering the issues under EA, I'm concerned about the hoops and that they won't be used for light deprivation. Light deprivation would be considered a mixed light permit and not outdoor. Furthermore, I feel that this project should have gone back before the city of Clear Lake after the first round of violations. The letter of support seems to be written prior to the violations, and I wonder if the entire council would agree with this project now. Number 5, CAL FIRE road standards were mentioned. At what point will those be put in place since they are not in place now? I've seen and I've been on this property, and it is far from compliant with road standards. Number 6, I'd like further clarification of the riparian water setbacks. There was a proposed change that is yet to be adopted, and this project would be held to original setbacks in Article 27 until revisions are approved. Thank you.
Thank you.
I think that he brings up some pretty good questions. Do you feel that the setbacks were adequate? I'm addressing the planner. The riparian areas.
Yeah, so for, it's been identified as Class 2, Class 3, Class 1 in the bio report.
Talking to the mic. Talking to the mic.
Hello? Yeah, so Class 1, Class 2, Class 3 in the bio report. So for the Class 2, Class 3s, it's 100 feet, which the applicant is going to do. They've proposed that it's 150 feet from a Class 1. So that is what the applicant has agreed to do with regards to the setbacks for the water courses.
Thank you.
And I believe I was the commissioner who made a comment about TBD, and I didn't mean that in a casual way, but just to respond to the caller, some things can't be permitted until we have approved the application, and so that was the context in which I was using TBD, meaning that specific permits for the roads or building a structure comes after the commission takes its action, just to clarify for the caller.
Okay, next hand, please.
All right, and the last hand we have up is Dave Hughes.
Okay, thank you. I thought there would be a couple of other people. I know there was well, never mind. I'd like to first address the early activation and the letter of support. I did go to the city council meeting when that was discussed, and I argued against it. One of the things I didn't say at the time was the city of Clear Lake does not allow growing outdoors within the city limits. And I believe that the county has a very good program when they talk about the 1,000-foot setback. And one party already brought up odors. I brought up odors at the hearing, and one of our city council people said, Hughes, it probably doesn't matter if it's 100 feet or 1,000 feet, you're going to smell it anyway. I will never forget that, and someday I will deal with it. But I would like to see the letter of support be issued prior to this use permit being issued, and I want it to go back to the city council. I'm representing at least 13 people that live in Burns Valley. I live about a block away from the highway, which makes me like 2 or 3 blocks from these projects. 11 of us have kicked in money. We have appealed the approval of the use permit that the city issued last week at 2185 Augulin Canyon, which is just inside the city limits. And we are getting more organized. So I'd like to see a letter of support from the city council prior to issuance of this use permit. Mr. Knoll mentioned that the early grow no longer applies to the site. It's a clean slate. So if we have a clean slate, let's get a new letter of support from the city council. Let's see. Again, grow sites A and B both look to be, you know, within a few hundred feet of the city limits. There was a kennel at 2160 Augulin Canyon, and I was talking to her the same time period as this early grow was issued. She was concerned about it being that close. She has it was the next property to the west of this site. The kennel had been there for years. She was concerned about the effect of the marijuana or the cannabis being grown actually affecting the health of animals that she might kennel. What she was told was probably worst case scenario, the owners will pick up their animals and the animals will smell like cannabis. She no longer owns the property. She has closed down the kennel, and I believe the property is now owned by Augulin Estates Holdings, which I believe also was involved in the approval of 2185 Augulin Canyon, which is also, I believe, some of the ownership on this property at 2050. So I know there was a mention of promoting the economy and it'll provide jobs. Here's a case where we had a business close because of allowing the cannabis within 100 feet or so of the property line. So we have a policy not to impact neighbors. Well, that one was certainly impacted and she sold out. I agree that the property owner is ultimately responsible for whatever action is taken on that property owner's property. And the property owner should have been a better property owner and kept up with what was going on the property during that early growth. The next thing I want to talk about is water. CEQA section 15355 talks about cumulative impacts. And cumulative impacts refer to two or more individual effects which, when considered together, are considerable or which compound or increase other environmental impacts. A, the individual effects may be changes resulting from a single project or a number of separate projects. B, the cumulative impact from several projects is the change in the environment which results from the incremental impact of the project when added to other closely related past, present, and reasonably foreseeable probable future projects. Cumulative impacts can result from individually minor but collectively significant projects taking place over a period of time. And if you look at the hydrology study, I believe the last sentence is, well, basically, we used to grow hops on this property and the cannabis will use less water and therefore there's no cumulative impact. I think that is short-sighted. I think somebody needs to step up and make people in this area be accountable for what's happening. One of the interesting things of the hydrology study presented with this application is a map that shows the Burns Valley watershed. And I had no idea where the Burns Valley watershed used to go until I saw this map. It extends up Highway 53 almost to Highway 20. On the west side of the highway, there's
Mr. Hughes, you're at the 3-minute mark. Can you please wrap up your comments?
I'm representing 11 people. Can I have 3 minutes with each of those, please?
No, you cannot. You can wrap up your comments, please. I'll give you another minute or so.
I think that's totally unfair, but okay, let me real quick. There's a 500-acre vineyard. People thought in the Burns Valley Basin that they were affected in their wells when that went in. Now you have on the east side of the highway 2 existing permitted grows. I understand today I got a text, there's a well being drilled on the east side of Highway 53 towards Highway 20. There's another approved just north on Augulin Canyon, north of this project, that's approved but not yet in operation. There's an approved cannabis project that includes 30,000 square feet of growing at 2560 Highway 53. And now you have the 2185 project, which we have appealed, and now we got the 2050 project. Nobody is looking at the cumulative effect of what's happening to the water in the Burns Valley Basin. The water drains and comes down, and Burns Valley Creek goes by my house. It's been mentioned, somebody needs to deal with the impact. I realize the drought has some impact on our wells. I put in a 3,000 gallon storage tank this summer. My neighbor has a 3,000 gallon storage tank. The Sullivans have a 3,000 gallon storage tank, and we're at a point where they flush their toilet only once or twice a day. And again, I understand the drought probably has something to do with that, but we have a cumulative impact on the water. Even the applicant on 2560 Highway 53 told me in a conversation, this is firsthand, oh, there's an aquifer that comes down and flows through and goes into the valley, and there's plenty of water. And my well's at 40 feet. The head of his well was 40 feet below the surface. About a month later, we were talking again, and he said, oh, my well dropped to 85 feet below the surface, and we're not even using it. You know, something needs to be done about the water. And I know there's a management plan of 2006. It's 15 years old. It needs to be updated.
Okay, Mr. Hayes, I'm going to ask you to conclude right there. Thank you.
Well, okay.
Do we have any other hands in the Zoom room, please?
Yes, we had some other hands come up here. The next hand I have up is from Vicky Crystal. Vicky Crystal, I've given you permission to speak.
Actually, this is Vicky Crystal. However, Dave Goolsby is the one, he's sharing my computer. He has something to say as well.
Yeah, my name is David Goolsby. I also share the concerns about the cumulative effect of just continuing to add more agriculture in this area, considering that there's just so many of us in the Burns Valley area that are already losing our wells. And I realize some of that has to do with the drought, but that just exacerbates it. There's no question that when the vineyards went in around us, that we started losing water in the mid to late summer. Our water pressure would drop off. I could almost tell when the vineyards were watering because our water pressure would just suddenly drop and it wouldn't recharge very quickly. So, and just as a matter of clarification, we definitely have seen Thule elk here out on Pond Road, out on the sewage treatment plant property. But anyway, that's my primary concern, is that we really need to start considering what is sustainable in terms of, we can't just keep giving more and more permits to draw water out of this aquifer without some understanding of whether it's got the ability to recharge. So thank you very much.
Thank you. Next hand, please.
Okay, the next hand I have up is from Kathy's iPad. Giving you permission, it looks like you're unmuted. Will you please confirm your first and last name?
Yes, my name's Kathy Qualls, and I'm sorry to have to continue on this with you. I know you guys are exhausted. You've gone through so much information. There's a lot I'd like to cover, but I'll try to make it as brief as I can. I live in the Burns Valley area. I did some research. I went on to the Lake County website, to the Groundwater Management Commission, and I won't give my opinion so much as I just want to state some facts that is in that particular site, where it brings up about the water issues, and it talks about that, let me see, there's section 2.5, the table 2 through 5, Burns Valley Groundwater Basin, During an average year, surface water demand is 91 acres a foot. It says the table also indicates that the groundwater is the primary source for this water basin of the Burns Valley Basin, and that the Watershed Protection District works to protect and maintain resources in Lake County. So my fear is that in these articles that I read that is on the website, it says that urban water demand is anticipated to increase 81% by 2040. Now that's not, that information that's on the website's already been there. This is before we're even considering this huge growth. It also has things in there that state that they need to keep in mind that water is such a huge resource. And I feel that, unfortunately, there's already like 3 of these sites out there. How much are they going to pull from the Burns Valley Basin? If we need to have these many grows because we need the tax dollars or whatever the reasoning is behind this, I'm not sure. But if that's the reasoning behind it, why can't we spread it out through Lake County? Why have this absolutely huge grow be put in so close to the city limits? Not only is it a concern for water supply, it's a concern for contaminating our beautiful lake where people want to come here. We have this beautiful gem here, this lake. The water is our draw to be able to draw good quality people. They're not going to want to come here with 5,000 marijuana grows, and this is a huge one. Also, it's off of Highway 53, one of our main corridors. They can say all they want about protecting, being able to get in and being, they're trying to make it look like it's hidden behind the corridor where it's not going to be seen. It doesn't have to be seen. Dirty things are usually done unseen. And that's what I feel is going on. I think that in their response to, which, thank you very much for the questions that you asked them that they were not able to answer. There were no direct answers to the questions that you asked. There were so many inconsistencies in what these people are saying. I really, please ask you to consider what is on our website at the Lake County site under the water section of water management, because it says it all right there. And then when you find that it also gives in the Burns Valley Basin, there's 86 domestic wells, 13 irrigation wells, 0 municipal wells, 3 monitoring wells, as 9 other wells. So altogether, there's 111 wells that was on this table.
Okay, Ms. Quarles, you're at your 3-minute mark. If you can conclude, please.
Oh, I will. I'm sorry. I tried to get as much in as I could. I really appreciate you listening to us. Please consider the fact of our environment, our beautiful gem that we have here, that we need to protect Lake County. We need to protect the quality that we have here. And we already have a bad reputation for drugs. I'm not opposed to people growing, but does it have to be all in one place? It's just a huge grow, and I ask you, please look at all the facts. And thank you for listening to me. I appreciate it.
Thank you. Do we have any more hands in the Zoom room?
There are no new hands in the Zoom room. I do have a repeat hand from Dave Hughes. I have a new hand that just raised from Garrick Burdick. I've given you permission to speak.
Hi, we are the applicant, and my name is Brian Pensack. We have someone online to answer the question about the water, please. What? Hello, were you able to hear what I just said?
Yes, we can hear you, and anybody on the applicant can speak.
Oh, okay, hi. Yes, my name is Brian Pensack, one of the applicants. And I have Angie Dodd online to just kind of address the water comments that people were making.
I've found her in the Zoom room and I've given her permission to speak.
Thank you.
Yeah, I was going to wait until all the public has a chance to comment so that I can respond appropriately, if that's okay.
That'll be fine.
Thank you.
Okay, do we have any new hands in the Zoom room?
I do not have any new hands in the Zoom room. I have a hand raised from Dick Hughes and Kathy, who have both made comments.
Council, can we allow them to comment again? Raise your hand, Mr. Hughes, and I didn't hear the last name of the other person.
Whether or not you can allow, whether or not your commission allows repeat commentary or comment from the public would depend on your commission. Often when that is permitted, bodies choose to request commenters to keep their comments restricted to things that have not been addressed already.
I'm always in favor of listening to the public.
Of course you are.
But please, let's not repeat ourselves.
Of course, we're interested in what the public has to say, but it is important to bring new ideas or new information before the commission rather than stating something that's already been used. And I understand Mr. Hughes' interest in speaking longer, but I don't think we can get into a situation where we keep adding 3 minutes and 3 more minutes and 3 more minutes, and then it's a half an hour. If you're going to speak, I think you need to show up either in person or via Zoom.
I'm in agreement. Mr. Hughes, if you have any new information, that'll be the request.
I can be very quick. I just
Do you
wanted
have
to
new
point,
information?
Yes, I just wanted to point out that there are properties owned by Lake County Investment Group, who does growing at 950 Junction Plaza, 152 acres, 1000 Highway 53, 47 acres, 1275 Highway 53, 57 acres, 1150 Highway 53, 112 acres. There's a property at 1020 Junction Plaza of 51 acres that's a grower. 1756 Ogden Canyon Road is 51 acres. That's a grower. Then you've got, again, the 2185, that's 21 acres, an approved grow that we've appealed. And then this property at 2050 and 2122 is over 300 acres. I just wanted to point out that there is a lot of interest in growing in that area, which was already mentioned, and all of those people grow. Thank you.
Thank you. Is there any more hands in the Zoom room?
Yes, there is one more repeat hand from Kathy. Kathy, I've given you permission to speak again.
I thank you for this. I won't repeat myself. I'm just asking you to check those tables that I asked you about with the groundwater. This is not an opinion from me. This is written word through what the county has as their guidelines for water management. And the inconsistencies and her wanting to speak after the public is because they want to get the last word in. And they've already addressed the issues too on the water. So could maybe our guidelines for the County of Lake be the last word? That's all I'm asking. Thank you.
If there's somebody who hasn't spoken yet and wishes to speak, I don't see how we can possibly tell that person they can't be a speaker. I'm referring to Ms. Dodd.
I'm in agreement as well.
I think Ms. Dodd will probably address what I wanted to talk about, but I wanted to answer some of the hands in the Zoom room, but let's hear from Ms. Dodd first, please.
Hi, this is Angie Dodd. Can you guys hear me?
Yes.
Can you guys hear me?
Yes, we can hear you.
Hi, this is Angie Dodd. I just wanted to answer some questions regarding hydrology. Nothing I'm going to say is new. It's all in the hydrology report that was submitted with the application as required by state ordinance. I just wanted to comment on, one thing that I do use in my research in terms of the groundwater hydrology, which is a very complex analysis. There's a lot going on for groundwater hydrology and groundwater resources. So one of the resources is the Lake County Groundwater Management Plan. And yes, in Burns Valley, referring to the table, there are 162 acres. This was back in 2006 when it was done. Of the land in the Burns Valley is irrigated by surface water, and then 5 acres by groundwater. I'm sure that has changed over time. In terms of this specific project and just talking about wells in the aquifer, in this aquifer, there are 3 water-bearing formations. One of them is the alluvial formation, and then there are deeper formations. 3 of the groundwater wells for this project are within the deeper formation. And in terms of, again, groundwater hydrology is extremely complex. So without knowing where parcels are, how deep wells are, how old wells are, how well they've been maintained, it's really difficult to say what's causing wells to go dry. Typically, the way it works is wells in shallower, unconfined aquifers tend to go dry more than those wells that are in deeper, confined aquifers. And the shallower wells are also more impacted by drought situations, which is what we're experiencing this year. In terms of this project and baseline conditions when looking at the water, groundwater resources and water supply and demand, this project is replacing a 13.9 acre hop farm. And hops tend to use about 5,800 gallons per day per acre for water needs. And cannabis tends to use, and these are averages overall based on the state Department of Cannabis Control, EIR. Cannabis uses 3,000 gallons per day per acre. So in the analysis here, baseline is what the hop farm used. And the cannabis is using much less, on average use much less than the hop farm would use. In addition, the basin that we're in, Department of Water Resources estimated a capacity of the aquifer of 4,000 acre feet, and the usable storage capacity is much less than that. It's 1,400 acre feet. When you look at this project, its demand is about 25 acre feet, so it's much less than the usable storage capacity. If you add another 40 acres of potential development of cannabis in the basin, if you use that 3,000 gallons per acre per day, that demand would be an additional 66.3 acre feet. If you look at the total demand of those potential cannabis projects and what's going on in the basin, that would account for about 100 acre feet of water per year, and then you have a usable storage capacity of 1,400 acre feet. So, but with all that being said, I understand what the public are saying, and I've written a few drought management plans to support projects in Lake County, as well as hydrology reports to support projects in Lake County, and in everything, in most, if not all of them, I've recommended both seasonal groundwater level monitoring of project applicants' wells, as well as monitoring while they're using the wells. And what seasonal monitoring will allow you to do is determine if the aquifer that the well is drilled into, whichever water-bearing formation, is the project actually decreasing that level of water in the aquifer, or is it recharging from year to year? So I think, in terms of long-term management and sustainability in the Burns Valley Basin, the key is groundwater level monitoring. That's also a requirement of the Lake County Cannabis Ordinance in Article 27, Section 18. So I'm here to answer. I kind of spewed a lot. There's a lot going on. Like I said, groundwater is very complex. I got some info out there. If you have any additional questions, please just let me know.
Okay, thank you. We're going to close public comment, bring it back to the commission for questions.
I want to thank everybody who spoke in the Zoom room. I think Vicki Crystal, David Hughes, David Goolsby, Kathy Qualis, John Wilcox, you all addressed the concern about water, and that's why we require hydrology reports for these. And I think Angie Dodd kind of reviewed what we have looked at, which is a 27-page report. You can look at it online. That satisfied my concerns. I'm not a hydrologist, but the recharge rates, it looks like we're not introducing something new here. But I do think that you have a good point about the cumulative impacts of these water draws, and we need to continue to keep an eye on this. The other issue that was brought up that I think that this county is not doing a good job with is the volatile organic compounds that are coming off of the plants. We do not have anything in our ordinance that allows us to regulate that. I'm talking about the odor. So maybe that's something that you can take up with your supervisor. Maybe when this ordinance is revised, maybe that's something that the county needs to examine. That's all.
Thank you.
Mr. Chair, I know I'm a broken record, but I still don't quite understand the mystery about the letter from the city of Clear Lake. I believe it was created, but I still don't understand why it's never been made available to the commission or made part of the record. And I also, depending on when that letter that you're going to show us was written, I think one of the callers makes a legitimate point about, is that still how the Clear Lake Council feels, even though the letter was written in February? And I'm hoping perhaps Mr. Flora could speak to that. I'm just a process guy, so.
No problem. That's why I'm spending my morning here. And, you know, I want to clarify, like, we're not here as an active supporter of this project. In fact, the city never requested or was consulted when the county ordinance was put into place related to this. And to be honest with you, my feeling, and I believe that of a majority of the council, the preference would be that this wasn't even included in the county ordinance, because, you know, we're not the regulatory agency for this property and this project. But because we were put in that position, we saw two impacts that are going to potentially be a result of this project. One, the only access is on a city street, and this project is going to have impacts. Now, we did an analysis with our city engineer. We came up with a budget estimate, some improvement plans, and using information from the traffic study, determined what would be a reasonable share for this project to contribute to the city improving that street. And the other, because the county has no sustained law enforcement presence in that area of the county, that if there are security concerns, the people who are going to be called to respond first is going to be the Clear Lake Police Department. Our hope is that that's not necessary, and the security plan, we believe, will address those concerns. But, you know, the legal advice that our attorney gave to the council is we have to be really careful here in treating this like we have some regulatory control of this project. And so I don't believe I've had conversations with council members throughout this process on this project and the current status. I don't believe that there's any need to go back to the council to look at this again. I believe the result would be the same. If there's any ask that we would have, I mean, maybe the Board of Supervisors could look at just amending the ordinance related to this, because we feel like it puts us in a position where folks are looking at us to take some sort of enforcement or regulatory action on a property that we have no authority, and we're relying on the county to do that. So I don't know if that addresses any questions you have, or you have additional questions, but that's kind of the position the city's in.
No, thank you, and thank you for providing a copy of the letter, Mr. Knoll.
Can you please state your name for the record, Mr.
Alan Flores, City Manager.
Thank you. So we have any questions from the commission? Okay, well, I'll go. I think, this is, for me, this is definitely a concern, the cumulative impact. And so as I've sat here and look at this project, and I think about and hear the concerns that are addressed, I have a question for council, and if there's an appeal by the citizens on the project at the City of Clear Lake, how does that impact any decision we make? Does it have any impact on a decision that we're making?
Are you asking that if someone files an appeal with the City of Clear Lake?
Yeah, regarding this project.
That would not be an option here. This is an action by the county and county unincorporated space. The appeal would be with the county, so any appeal of your decision would follow the appeal process of the county, which would be to the Board of Supervisors.
Okay, thank you for that clarification. And so I know the concern for Burns Valley Creek. I haven't seen water in that creek in years, other than seasonal during the rainy season. And also I'm following closely the development that's happening with the Little League facilities that's going in the same area around Burns Valley Creek, and again, the cumulative impact of water. And so that's one of the concerns I have is I hear loud and clear, and it's coming up more and more, the question of water. And so in terms of our ability to look at the studies and take that into consideration in our decision making, the studies say what they say, but again, I'm concerned of how does this impact the future. I think the other questions I have been addressed, the concerns, which weren't, rated very high in my mind in terms of the questions I asked earlier, but I do have the concern with all of the information that's provided by members of the community, and a lot of questions were raised. And so kind of following that, in terms of the study, I'm concerned with the water. And so I know Angie spoke to some of the technical issues in the reports, and so I'm just trying to find the nexus for myself to support this project with all the concerns. So I don't know if anybody has any other questions or...
Sure, I have a, question and comment. So, for example, a year like this, if the following year is the same, and you plan on doing 15 acres, would you take into consideration reducing that amount of, at the end of the day, it would be your decision, whatever we approve today, but in order to kind of offset that, according to your drought management plan, it says steps that would, or drought emergency water conservation measures. So would you do that to not do the full amount of acreage and reduce that? If you could make that commitment to,
We have included that as like a measure in the drought management plan. We really feel like it won't be a problem on this particular site with the amount of water they used for the hops over the last 15 years being almost double. And so we're confident that we won't run into a problem with our wells running low or being not sufficient for the project, but we do have it in the drought management plan as an option if we don't have the adequate water or if there's a problem with other properties, like we're definitely willing to look into that. But we feel like we have like a lot of water.
and also, regardless of a drought year or not, are you going to do everything in your power to meet those water conservation needs of using mulch, plastic cover, and all of that?
Yeah, yes, we designed all those measures.
Thank you.
A question to council. Since there are only 4 commissioners present and voting, as I recall, a 2-2 vote would result in denial of the application.
A 2-2 vote is a no action, which would be defined as a denial.
saying if it was a tie vote.
Yes, that would be no action.
Correct.
Which is a denial.
Okay, do we have any other questions for the applicants? Any comments or want to take action on the project?
I'm ready to make a motion to approve this based on extensive evaluation. I think the applicant made a really good point that the prior use was agricultural. I'm not sure about the quantity of water, but I'm familiar with that hops yard. I think we might have even done some work there. We're not talking about new water consumption, and this applicant, unlike other applicants who've come before us, clearly has adequate supplies from the Cache Creek Formation that underlies the area. It's not just Burns Valley runoff. So taking that into consideration, I'm ready to make a motion.
If I could just comment before the motion's made. I associate myself with the chairman's comments and share his concerns about the future in terms of the impact on the Little League team, the water, et cetera. But I'm always concerned when the absence of a commissioner could create an outcome that wouldn't have been otherwise created if all 5 of us had been here. So just reading the tea leaves, I'm prepared to support this application and not create a situation where a technical 2-2 vote results in denial, because we're just not sure how our absent colleague might have voted today.
Okay, thank you.
I'm not going to try to figure that out, but I get what you're saying. I move that the Planning Commission find, on the basis of initial study 1956, that the major use permit number UP 1936 applied for by Lake Vista Farms LLC on property located at 2050 and 2122 Augulin Canyon Road, Clear Lake, further described as APNs 0105301, APNs 010-053-01 and 02 will not have a significant effect on the environment, and therefore mitigated negative declaration shall be approved with the findings listed in the staff report dated November 18th, 2021.
I second.
Okay, all in favor?
Aye.
Aye.
Abstention? 1 yes.
I further move do we want to do a roll call? Okay. I further move the Planning Commission find that the major use permit UP 1936 applied for by Lake Vista Farms LLC on property located at 2050 and 2122 Augulin Canyon Road, Clear Lake, further described as APNs 010-053 and 01 and 02, meets the requirements of Section 51.4 and Article 27, Section 1, IIG, III of the Lake County Zoning Ordinance, and the major use permit be granted subject to the conditions and with the findings listed in the staff report dated November 18th, 2021.
I second.
All in favor?
Aye.
Aye.
Opposed? Aye. Okay, we'd like to note that the applicant or any interested person is reminded that the zoning ordinance provides for a 7-calendar day appeal period. If there's a disagreement with the Planning Commission, an appeal to the Board of Supervisors may be filed. The appropriate forms and applicable fee must be submitted prior to 5 p.m. on and before the 7-calendar day following the Commission's final determination.
Mr. Chair,
Yes.
I have a suggestion on how to handle the prior decision on continuance dates. Your commission, someone could offer a motion to reconsider that decision for the narrow scope of reconsidering the continuance date. There would be a vote on that motion. If it passes, then your commission could reconsider the date, decide another date certain. There would be a motion then to adopt that an agreed upon new date certain, and then a vote. And if that passes, then that could be the new continued date certain. Staff, however, would have to renotice the item regardless of whether or not it's a date certain, because there may have been people who had gone from the meeting relying on your previous vote.
I just need to be refreshed on what the switcheroo is. Which should be the 13th and which should be the 18th.
Item 4 should be January 13th, and item 3 should have been in December.
That's correct.
Okay.
I move that we reconsider the continuance of item 3 on today's agenda to continue it until our regular December meeting.
I second.
All in favor?
Aye.
Aye.
Then you would need another motion to actually adopt the date and time certain, and a vote to adopt that date and time certain.
I so move.
All in favor?
Aye.
Aye.
Just so we're clear, the date and time certain, that item number 3 was moved to December 9? Not December 9, my apologies, that I was looking at January the 13th. Was it 13th?
I think it's the 15th.
Is it the 15th?
January the 13th.
We have a meeting.
The second Thursday in December is the 16th.
Is it?
No.
No, it's not the...
The first Thursday in December is the 2nd. The
Right.
second Thursday is the 9th.
Correct.
Oh, yes, that's right, that early Thursday on the 2nd.
But I had it in my mind that we have a meeting on the 16th.
I believe the calendar shows just
Let me
one
just-
meeting for December on the 16th. Yeah.
Good thing I asked.
The 16th then?
The 16th.
Pretty sure.
Okay,
Okay.
so it was to the 16th, regular meeting. Okay.
Correct. Okay, any untimed staff updates?
We always use this time for any staff updates or office news from the director.
Oh, hi. Are we off or is this?
No, we're still in. You don't have to have an update.
I don't have an update.
Okay,
So this is Mary Darby, and I don't have an update at this time. Thank you.
thank you. Okay, we'll move to adjourn the meeting.
I so move.
Okay, all in favor? Aye. Meeting adjourned.